Morning. We have one case on the 10:30 docket, 127162, State of Kansas versus Montgomery. Council, please state their appearances.
May it please the court, Tremelle Montgomery appears through counsel Jacob Nowak at the Appellate Defender Office, present and ready for argument.
May it please the court, David Loudon, Deputy Riley County Attorney, appearing on behalf of the state of Kansas, present and ready for argument.
Thank you, counsel.
May it please the court, Tremelle Montgomery appears through counsel Jacob Nowak of the Appellate Defender Office. Chief Justice, may I please reserve 3 minutes of my time for rebuttal.
3 minutes is granted. Thank you.
Thank you. This case highlights how a single ruling can undermine the credibility of an entire trial. Because this was a self-defense case. The question of who shot and killed Mr. Wardy was never at issue before the jury in this case. Rather, from essentially the moment of Tremelle's arrest, he advised police that he shot Mr. Wardy in self-defense. Tremelle then brought 2 witnesses to preliminary examination to support his theory of self-defense. He abandoned what I think was probably a winning Jackson v. Deno argument because his statements to law enforcement supported his theory of self-defense. And he, at trial, got up on the stand, waived his Fifth Amendment right to be free from self-incrimination, and told the jury that he shot Mr. Wardy in self-defense. The only issue for the jury to resolve in this case was whether or not Tremelle's actions were either justified or mitigated as perfect or imperfect self-defense. But the jury never got to consider that issue because the court took it out of his hands. That cannot stand because when Tremelle got on the stand and waived his Fifth Amendment rights to be free from self-incrimination, he did so in reliance on both the legislative guarantee that he would receive an affirmative defense instruction for every defense that was supported by substantial competent evidence, and in reliance on this court's guarantee that his testimony, standing alone, would satisfy substantial competent evidence for that instruction. So when the district court ignores legislative intent in this court's case law and denies Tremelle his requested affirmative defense instruction, not only is it denying Tremelle his right to present his theory of defense, it also has effectively duped him out of his Fifth Amendment rights and turned his testimony into, or as far as the jury was considered, or as far as the jury was allowed to consider, a confession to murder, which then forced his defense counsel, presumably against Tremelle's wishes, to present a guilt-based defense on the fly during their closing argument. That's what I mean by how a single ruling can change or can undermine the entire credibility of a trial. If precluding an instruction prevents the jury from returning any verdict other than guilty, then for all intents and purposes, we didn't have a trial. As far as the court's rationale for not giving the instruction is concerned, it's fairly easy to see where the court went awry. The first thing it did was it conflated 2 different types of voluntary manslaughter analysis. The legislature has decided that both voluntary manslaughter under heat of passion and voluntary manslaughter imperfect self-defense are going to have the same name. I'm not sure why, as they don't have a lot in common. But what the court did in this case first was review this court's case law on voluntary manslaughter heat of passion. And it latched on to the phrase or the holding that mere words can never justify a heat of passion or a voluntary manslaughter instruction under a theory of heat of passion. It then applied that here to Tremelle's requested imperfect self-defense instruction and said that it wasn't going to consider the threat made against Tremelle's group when it was conducting its analysis, because those would just be mere words. But as we know, the statute allows people to defend themselves against an unlawful use of force. And we know the statutes do not just limit that to physical uses of force. It includes a threat to commit violence. You are allowed to use force against a threat of force. So that statement alone would have justified giving these self-defense instructions. Of course, we don't have just that statement alone. The situation in this case, all of which took place in approximately 3 minutes. Tremelle had never met these individuals before. After he was released from the Aggieville substation, he goes over to his car. He meets his friends, Edward and Jordan. He hands Edward his keys because he doesn't want to, and I apologize if I'm getting Edward and Jordan confused here, but he hands Edward his keys because he did not want to risk getting a DUI. He then begins digging in his car for his cigarettes. While he's doing that, while he's talking to Edward, he hears Jordan arguing with a group from across the street. He's not paying it very much mind at that time, not until he hears what he perceives to be a threat to shoot based on his prior experiences both in Atlanta and in Manhattan. Hearing these types of statements, I believe it was specifically those statements in Atlanta, and he had just recently witnessed shooting in Manhattan. But
Statement being stay over there. I think it's important to specify what the words are.
right, there's a little bit of conflict in what the statement is. That was Tremelle's testimony. I suppose if we view the evidence in the light most favorable to Tremelle, we would adopt Mr. White's testimony, which was that Mr. Bastian shouted, "Stay right there, we've got something for you." And his testimony that that was intended to be a threat against Tremelle's group. Now, granted, Mr. White attempted to walk back that statement that that was a threat at trial. He still said it was a threat, but he said, "Oh, I never said what that was a threat of. It could have been anything. We could have been threatening to call their parents," which I think is a pretty absurd interpretation of that threat. But yes, that is the statement that was made to that effect. And Tremelle provided additional testimony, I think probably recognizing the ambiguity of that statement, explaining that that statement is meant to be a threat. He's seen it be a threat. He's seen people be shot immediately preceding that statement being made before. And it's also important to recognize when we're talking about that statement that Tremelle didn't immediately use force in response to it. He recognized that there was a threat of violence that was made against him and his friends. And what he did was a lawful action. He brandished his firearm and he placed it in his waistband publicly so that the other group knew that they had means to defend themselves if they did intend to act upon that threat. He did that to try to de-escalate the situation, to try to get Wardy's group to disperse. And by and large, it worked. 3 members of Mr. Wardy's group ran away at that point. Not Mr. Wardy. Mr. Wardy turned around towards Tremelle, walked towards them with what Tremelle described as with a purpose. Tremelle is in slight fear at this point because he does not know if Mr. Wardy is armed. He knows that a threat was made against him, but he doesn't know if he's armed. As Mr. Wardy gets closer and closer to Tremelle, Tremelle eventually pulls out his firearm and points it at him in an attempt to get him to stop. Mr. Wardy does not stop. He continues to walk towards Tremelle with a purpose. Again, Tremelle does not know if Mr. Wardy is armed at this point, but now it no longer matters because he has gotten within range to disarm him. And then in the final moments, when he is within a couple of feet, as unbiased witnesses said, able to reach out and grab him if you wanted to, Tremelle finally shot. Other witnesses said that in that moment, Mr. Wardy's hands were reached out as if they were trying to get Tremelle to stop. So there is substantial competent evidence that there was a threat of violence made, that Mr. Wardy had walked towards Tremelle after that threat of violence was made, after Tremelle had indicated that he obviously perceived that as a threat of violence, after he attempted to get him to stop his advances, movements, and eventually got within range to disarm him, all before Tremelle finally, as a matter of last resort, acted in self-defense. There's also physical evidence that Mr. Wardy was not shot after he was incapacitated. None of these shots took place while he was on the ground, which is of course indicative of self-defense and not premeditation. There is other evidence. Again, the fact that the Wardy group initially lied to police. They told them that Tremelle's group had jumped them outside of Aggieville and only changed that statement, that story, after the investigation revealed that that was obviously false. At that point, they changed their story to try to blame Tremelle's group for starting this argument. And then there is also the fact that they corroborated the fact that a threat was made. So we have that.
The district court's ruling on the self-defense instruction was hinged on the district court's belief that objectively there's no reasonable person could have believed that deadly force was necessary.
Yes.
What would you point to in the record that's, from your view, would specifically be evidence that an objective person, not not your client, but an
Sure.
objective person would have reasonably believed deadly force was necessary?
Aside from my client's testimony,
Well, this is the objective person prong, so I'm not sure your client, I mean, maybe, yeah, you can include your client's testimony.
Sure.
But
Well,
anything that would go to what an objective person's reasonable belief.
I only do so because this court's consistently said that the defendant's testimony standing alone can satisfy that objective prong. In addition to that testimony, I would say that the state presented two groups of witnesses. Essentially, you've got the Wardy group who saw the beginning of the interaction, and you've got the Mr. Tavin and the two high-low workers who saw just the seconds at the end of the interaction. And that corroborates substantial portions of Tremelle's testimony. One, the Wardy group corroborates that a threat was made. And two, the final group corroborates the fact that Mr. Wardy had gotten within feet of Tremelle before he finally decided he needed to fire. So when you couple the fact that there is a threat of violence, a threat to shoot, with the fact that then Mr. Wardy approached, a rational jury could find under those circumstances that deadly force was justified, or at the very least, an imperfect self-defense lesser, that Tremelle justifiably believed it was justified, even if not objectively reasonable. Either way, those are going to come down to questions for the jury to assess the credibility of each witness who testified and determine whether or not.
Is objective reasonableness a factual or a legal question?
Objective reasonableness is a factual question for the jury to decide. We've got 12 objectively reasonable people that we've brought in, and we've taken away from their jobs, families, and responsibilities to resolve these factual disputes.
So you don't think a judge can weigh all the facts in the light most favorable to the defendant? Let's say the judge says, we'll presume everything the defendant says is true, and still conclude that as a matter of law, these facts don't satisfy the objective reasonableness test.
I do not think so. I think a neutral arbiter who's going to be officiating an adversarial process should allow both sides to present their evidence, then instruct the jury on their respective theories of defense and allow them to resolve the disputes therein. I suppose there might be a situation where something is so absurd that could come into play. I certainly don't think it's here. I frankly think if we've gotten to that point, the better course is to issue or order a mistrial, because at that point there's been a material breakdown between the defendant and their attorney. If their attorney advised them to testify and waive their right for an affirmative defense that they were never going to get. I think once that defendant gets up there and waives their Fifth Amendment right, that's a very powerful thing that they're doing. And the courts need to respect that and instruct on the theory of self-defense that they set forth.
Can you help me understand, particularly on the imperfect self-defense instruction, that if there was error in failing to instruct, your view of the prejudice? I know it's state's burden, but maybe your response to their arguments that how it would not have impacted the jury's ultimate conclusion, maybe including partly because I think there was some argument by the state that, they're skipping, they're finding first degree premeditated murder, skipping lesser charges of second degree intentional.
Sure. Well, how
Your view of prejudice, in other words.
Absolutely. How it would have, I guess, broadly impacted how the jury would have assessed this is kind of a great unknown, because once you don't instruct on self-defense, again, you've turned Tremelle's testimony into a confession for first degree murder effectively. Obviously, it wasn't meant to be that, but once you preclude that in affirmative defense instruction, that's what you have done. That's why we had to present a guilt-based defense against our intent in this case. I don't read too much into, I guess, the skipping of second degree murder, because, and I suppose there could be self-defense cases where that might be applicable. But in this case, Tremelle talks about how he began to form these thoughts not well before, but a few moments before the actual shooting took place. And as this court's aware, The temporal and cognitive components of premeditation they can happen fairly quickly. So when you have Tremelle basically saying, I heard a threat, I believed at that point I needed to take some action in order to de-escalate it. So I grabbed my firearm, I put it in my waistband and tried to get the other group to disperse. One member approached me. I knew I was in danger at that point. I pulled out my firearm to try to get him to stop, to try to get him to leave the situation alone. He continued to approach, and as he got closer and closer, and I knew he was in range to disarm me, I finally decided I needed to fire. That is a lot of cognitive reflection. Obviously, it all goes to self-defense, but when you don't give that instruction to the jury, all they can do is look at that and say it must be premeditation.
How does the fact that this was an argument between two groups, as I understand it, on opposite sides of the street?
Yes, I
And
believe.
how does it play in that your client was the one that crossed the street? And it's really not accurate to just say there was a threat and the guy kept walking towards me. Your client is the one who crossed the street to confront. And really the victim just kept walking. I mean, he just was walking and he just kept walking. Right? Isn't that?
Disagree with your assessment of what the victim did in this case.
Okay,
I also
well,
largely disagree with any insinuation that that's turning my client into an aggressor. His testimony.
I'm
was
not,
that-
you can correct me if I've
Sure.
recited the facts wrong, but is that wrong? I mean, that is my understanding of what happened is that your client crossed the street
Yes,
with the gun.
correct. In
And
order
that
to
the
get them
victim-
to disperse,
Right.
which is
kept-
testimony.
Kept walking.
No, that the victim didn't keep walking, that his three friends ran away, that the
Right.
victim almost immediately turned towards him and walked towards him with purpose, with what he perceived as an intent to disarm him.
Wasn't he headed that way anyway?
That's what I thought. That's what I'm trying to get clarification. He didn't turn around. He was walking the same direction.
I believe the testimony, and I'll try to find a record site for you
Okay.
before I come on rebuttal, but I believe the testimony was that he had took a step after he saw the gun, took a step or two away from Tremelle with his friends who were running away, decided not this, walked towards Tremelle with an intent at that point to, what Tremelle perceived to disarm him, essentially. But yeah, I suppose my colleague can correct me if I'm wrong, but I believe that Tremelle or Mr. Wardy initially took 2 steps away and then turned around.
Let me ask you this, just jumping off with Justice Stiegel was. The facts show that they're getting ready to leave. And he doesn't want to drive, right? And so he hands the keys and they're getting ready to get in the car to leave. And then he hears this threat. And so instead of leaving, he crosses the street.
Yeah, Kansas doesn't have a duty to retreat.
Well, that's not retreating. You stand your ground.
Leaving? Or
But
Sorry.
retreat is, like if someone's coming toward you, you don't have a duty to retreat. But there was only one person that was, that would more be the victim saying, I don't have a duty to retreat.
I would say that if someone threatens to shoot at an individual and that individual then, to avoid that threat of violence, gets in their car and drives away, I would classify that as a retreat.
Well, this isn't a threat to shoot. This is,
In the light most favorable to Tremelle, it is.
there's no evidence of a gun,
No,
right?
you don't have to have a gun to threaten to shoot someone. That's part of the problem with criminal threats and aggravated assaults, is that you're putting the person in apprehension of a threat that they don't know if you can follow through with or not. Because guns can be concealed fairly easily.
Stay right there.
We've got something for you. Yeah, and that is what he said was a threat to shoot based off his experience hearing that and then seeing his friends be shot immediately thereafter. A jury can disregard that. A jury can find that that's not a credible statement, but for us on appeal, we have to view all of that evidence in the light most favorable to Tremelle. Tremelle said that that was a threat to shoot. He gave an explanation for that based on prior experiences where that threat was made and then proceeded by gunfire. I will make myself available for rebuttal, but if there are no outstanding questions, I will sit down.
Thank you.
Good morning again, David Loudon, appearing for the state of Kansas. Defendant has raised 4 issues in his brief, so preliminarily, I'll say that it looks like he's addressed one on this argument, and I will generally limit my arguments to that first issue, but I do have some comments regarding some claims that he was making, counsel was making in his reply brief, and I kind of like to start there just from a factual basis here. First of all, going to the comment that Mr. Wardy was walking away and met the defendant as he was walking west. I think that's the inclination of the court, or what they're reading. My view of the evidence is the same as Mr. Nowak's. And if you look at the video at the 12 o'clock, 31 minute, 55-second hour, that's where you're going to see, and that's in Exhibit 13. You're going to see, and there's testimony to that effect as well, you're going to see Josh Wardy walking past the substation to the west. There's also testimony that indicates, and this is a point of contention in the reply brief, that indicates that, and Detective Ulmer testified about this, you could see a figure that appeared to be coming across the street. So my understanding is he's walking like this. The defendant comes across the street and he turns right in front of high-low. And that's where it diverges. Did he step toward him? Or did he just stand there? Did he put his hands up? What did he do? And I think that's what the evidence would show. So it wasn't that he was walking and coming this way at him. Does that clarify that factual issue?
Somewhat, yes.
Well, I'll get into this. So as far as the other facts that I'd like to get into, there's a claim made that I didn't properly cite things in my brief, and I wholly disagree with that, although I did find a couple of citation errors. This court's rule is that I'm required to put a record citation to not only the record, but a page number in the brief to my factual citations in the statement of facts, which I did. There is no rule that I have to do the same thing over in the arguments and authority section. Now, whether I do that or not and help the court out that way, I think, we often do that, but I don't think it's a practice, nor is it a rule that I do that. Secondly, those citations that I made in the record, I cited to videos and still shots of the videos according to the testimony of the officer that was involved, or the detective, officer at the time was involved. In that statement, he indicated on pages, I think if you look anywhere from page 94 of volume 6 to page 100 of volume 6, you'll see that there's a discussion, a pinpoint discussion about what that video shows and these timeframes in which some of these events occurred. So the indication or the assertion of counsel that I didn't cite these things well enough is belied by the record itself, where this court doesn't need to go hunt things down in those videos. It's in the transcript of the trial, and you can reference that by looking at the videos. So with that, I will get into my argument here. With regard to the first issue, it's quite clear that this court is really the sole thing we're arguing about is whether the district court found that there was a that these instructions that have been requested on self-defense and voluntary manslaughter were factually appropriate. Mr. Nowak has properly indicated that we're supposed to look at that in the light most favorable to the defendant. I think where we depart is this notion that in a vacuum, the only thing that we consider is what he says, the defendant. I think this court also has to look at the underlying facts of the case to determine what that is. It's not required under that standard to ignore uncontested evidence in this case. Part of that uncontested evidence is that, and as you heard counsel, the defendant walked down the street. He had a gun. He got a gun, walked down the street, crossed the street to confront the Wardy group with this gun with the intent to intimidate them or threaten them, the gun in his waistband. His entire argument hinges upon the notion that he's not the initial aggressor. He's the one that started this. So he would like to isolate that one incident and say, if you take my client's view of the evidence, he took 2 steps or so toward me as I was approaching him coming across the street with a gun in my hand. That, along with this threat that was made seconds earlier, minute earlier, that's enough to get a self-defense instruction. That's enough to get a new trial. I would submit to this court that that's not the case. Okay? There's a subjective and an objective test to determine whether a defendant is entitled to a self-defense instruction. And to answer your question, Justice Stegall, the state believes that there is a judicial gatekeeping function, and I think our case law and the standards that are applied support that gatekeeping function by any district court. What also cannot be ignored is that the initial aggressor instruction is often coupled with a self-defense instruction. So the notion that, maybe he was just going to get the self-defense instruction and it would have turned the tide of this case, that's false. The prosecutor in this case asked for initial aggressor instruction if the court was inclined to give it. But at that point in time, the court had determined that it wasn't going to give it, or shortly thereafter, the court had determined that it was not going to give it. So this case isn't seen in a vacuum. As far as the sincere and honest belief of Mr. Montgomery, and that's a subjective problem, that self-defense was necessary, deadly force was necessary. Again, his claim is pared down to, they made a comment before they walked away. I walked down there with him. I crossed the street with a gun in my hand and I approached them. And then he made
the problem.
What's that?
Is part of the issue here, or part of is what the comment meant. Stay right there. We've got something for you. To Mr. Montgomery, that meant stay right there. I'm going to shoot you, or something along those lines.
Correct.
What if it was that direct, that kind of the common understanding of what Mr. Montgomery thinks or experience, we've got something for you, meant that? Would that make any difference? Or is
No, I'm taking that into account, that's
Okay.
exactly what he thought he meant.
Okay.
We do that in the context of subjective belief all the time, right? I've had history with this guy, and every time I walk up to him, he's always got a gun and he pulls a gun on me. I wasn't going to wait until he pulled a gun on me, that kind of thing. And I think here we can take it at face value, and as we're required to do by law, that he took it as a threat.
But I do just want to clarify in the record, and maybe you know or maybe you don't know. But it was my understanding, and I kind of looked at it just now too, that number one, he put the gun in his waistband before anything happened, right? It didn't have anything to do with anybody talking to him. He testified, when I get in my car, I always put my gun in my waistband.
Well, I could be wrong, but Mr. Noah correct me, but I thought he was in his car getting cigarettes or something, and then he retrieved his gun. He heard some things going on and some yelling, which I think the evidence would show he says he's not paying much attention to, but somehow it becomes all important when he hears that. So I think it was in and about that time that he armed himself.
Okay, and then the second thing is, I tried to find that stay right there, and then the part that says, I've got something for you. And the only time that I really see that it's it here is that it's actually the victims group. The defendants group that says, I've got something for you. And then when he's asked about that on cross-ex or on direct, I don't know, whenever he was asked, they said, and when did you say I've got something for you? And he says, I never said that. Did anybody in your group say that? No. When does he say that the other side said that? Am I missing that?
On page 2 of my brief, I don't disagree with you, because I think it was defendants, the testimony that I've got noted in my brief is that someone from the defendants group yelled, "What you looking at?" and "We got something for you." That's
Right, the defendants group.
right. And then it was Wardy and Bastion, that Wardy's group, that those two replied back, "We ain't worried about you all. Mind your business. Stay over there."
Right.
And that's my.
So there was
right.
no, I've got something for you said from the victims group to the defendants group.
That's correct. I don't recall that happening like that.
Thank you.
But I thought that the defendant's statement was just the stay over there was the trigger, because
Right.
those words are what triggered him. And at that point in time, that's when that was all being said. And I say, Mr. White saw defendant lean into the white car and grab something out of there. So that's why when you were asking about the statements, it's my understanding that he reached down after that.
You had emphasized the objective component to self-defense and how we should, keep that in mind. But for the voluntary manslaughter, imperfect self-defense, is the subjective view, once we sort out all the facts,
Right.
but viewed in the light most favorable to the defendant, is that enough? A honest belief, but unreasonable one, not objectively reasonable, but honestly held belief.
Right. Just while as I argue my brief, I don't think it's enough. Certainly when we're dealing with that subjective test, it becomes a little more difficult to gauge that. And I think ultimately, that's kind of why we fall back into that objective test a lot of times, because we need both of those things. But my argument is that he has to have even under the subjective test, he has to have a sincere and honest belief that deadly force was necessary. The state's position is that he did not have that. And I agree, and I did agree with you that in the brief that the objective test wouldn't factor into that voluntary manslaughter piece.
I will say, volume 8, page 161 is where he says that normally I just grab my firearm when I get to my vehicle. So you were getting your firearm before any altercation started? Yes, ma'am.
Okay.
So.
As far as I see that I'm running out of time, I do want to mention In the second issue, there's also been a claim that I didn't back up some of those, some attack on what I've written in the brief. And this is the piece where I would indicate to this court that I probably didn't put full citations to, there's a 6-point test that Mr. Nowak or I put in 6 points, I think, or so, factual points that would support the inference on the corpus delicti stuff. Most of it is focused on what the defendant has, and to the extent that that's true, I've neglected to include, a citation to the testimony from Bastian, White, Musgrave, and the officers regarding about what the videos showed and what they saw in person. So this isn't a situation where it's just the defendant's statement, and so I stand by that part in my brief. And just for this court's edification, I would just close by, because I know it's very difficult, I would say this. Mr. Nowak in his reply brief indicated he scoured the video and was looking and looking and looking to find something that showed the defendant crossing the street. Okay. There was testimony from Detective Ulmer saying, and you have to understand, I mean, these pictures had to be zoomed. They had to be stopped frame by frame. And I don't know how he's looking at it, but there was testimony from Detective Ulmer about how he was crossing the street. That would have been at the the midnight hour. So 12:32 at the 04 and 05 second part of that, where he's coming across the street. And Ulmer says, I think that he's coming across the street right there. And I kind of mentioned that before. And mind you, there was no objection from counsel when he was testifying to this. Like, there's no way you could see that. And you could see in these still shots, if you look at like State's Exhibits 16 or 15 through 21, you can see the still shots are a lot clearer than what you could perceive on the video. So I would just encourage the court to kind of look at that. And when we're talking about whether I've presented evidence or cited something properly, I submit to you that it's all in the record there. And there's no rule that says I have to pinpoint cite a video. Maybe it's convenient for this court, but Mr. Nowak couldn't do that either. So with that, Your Honors, if there's no questions, I would ask this court to deny each one of defendants' claims on appeal. There's 4 of them. I would ask this court to affirm the convictions and sentences. Thank you.
May it please the court, I guess I'll start with a little record cleanup that I was able to look at while we were during my break here. First, it was Tyrese White during his testimony, and I'm going to apologize because I used the record sites as just the full trial numbers, so you might have something different. Tyrese White did say that the statement was, wait right there, we've got something for you. Mr. White says that at record volume 7, what I've got down is 631 to 632. At 634 to 635, he attempts to walk that back and say he was just threatening to call their parents. And then at 647 to 648, defense counsel impeached him with his preliminary examination that statement was meant to be a threat towards Tremelle's group. I have that the gun was grabbed in response to hearing that threat. I don't think Tremelle believed that the threat was an altercation, because altercation implies something physical. But from pages 886, record or volume 8, 886 to 888, and 631 to 931 to 932 is what I'm relying on for Tremelle grabbing that handgun in response to the threat that he heard. And then
That's where I quoted from.
okay, I think then maybe we're interpreting altercation differently. I think Tremelle meant that to be the physical altercation had not yet started, but the threat had occurred. And then as far as it seems like the state and I are in somewhat of an agreement, I disagree with the fact that they're asserting that it was only 2 steps that Mr. Wardy took towards Tremelle. I don't think that is necessarily definitive from the record. I view this as it was several more, because he had time during those steps to pull out his handgun, point it to him, and then the steps continued to come toward him. And he was continuing to walk towards him with a purpose. As far as the reply brief argument and the discussion about the citations, what I hear is that Ulmer says he saw it, but I didn't really hear the prosecutor say that they can definitively see this on that record. And again, Montgomery's wearing a very bright red hoodie during this night. It shows up very, very clear on other portions of videos. I've watched that video well over a dozen times. I don't see the portion of it that Ulmer's talking about. And there is no trial objection to Officer Ulmer's lying. I mean, I know our clients wish that we could object that person's lying, but that's just not an objection that gets to be able to be made. And so I just want to stress, because I know this came up in State v. Ross as well. If the state is not going to supply adequate record citations, it really prevents me from being able to do my job to verify for this court that every assertion they're making is made within the record. Now, if the state's saying that is what a couple of the officers testified the video said, fine. I read their brief as them saying definitively that's what these videos show. And I watched those videos and I don't see it. Briefly, Jeff, the initial aggressor argument, I do want to note that that's not necessarily a defeat to giving a self-defense instruction. That is its own independent instruction. And we would acknowledge that the state should have gotten that instruction because the pendulum shifts there. When you're reviewing self-defense, you review that in the light most favorable to Tremelle. But then once the state requests their lesser or their initial aggressor instruction, they should get that benefit. They should get the evidence reviewed in light most favorable to them. And then we let the jury decide the facts as applied to those two instructions. For all these reasons, unless there are outstanding questions, I ask this court to reverse Tremelle's conviction and remand this to a trial where a jury can actually consider whether or not he's not guilty. Thank you.
See more questions. Thank you. Thank you to both of you this morning for your arguments. The court will take this matter under advisement